of all the things they don't like, disrespect towards a witness or the court or the court staff or another attorney, they don't like.
But you didn't throw the exhibit at anybody, so this
Certainly
was
not.
over the top. I don't know what the judge did. We need to ask the attorney what the judge did. I could see contempt. I could see I could see maybe a bar complaint. Even I could see the judge filing a bar complaint in that regard. I'm not sure. I don't have the rule on top of my head of what the bar rule. There's no specific rule about throwing things in a courtroom, but got to be cordial. So
I think the lawyer's creed. I've had judges ask me about the lawyer's creed, even though it's not binding, but some judges hold the lawyer's creed in high esteem.
we think the creed probably does say something about throwing exhibits or throwing, things at opposing counsel. Don't do it.
I think it just says be respectful or treat other attorneys with respect.
Yeah.
I don't know.
Welcome to episode 130 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is July 9th, 2026. I'm Phil Silberman, owner of the firm, and I'm joined by Chris Heald, who's the firm's managing attorney. Chris, how are you today?
Doing great, Phil.
Doing well. Is it back to school season yet?
Gosh, you asked me this last year and it was early and I was like, what are you talking about? That's my reaction again this year. You're the first one to say it. It's July 4th. What are we doing? It's not back to school.
I agree. It always bothers me. It's become like the Christmas season where, Christmas is wanting to start the day after Halloween because the retailers need to sell more. Back to school is big money, big business. And it always depresses me when I see the first back to school advertisement. So, yeah. Today on our docket, we're going to talk a little bit about why judges are panicking and kind of employing the rocket docket and why things in Texas are moving so fast. And then we're just going to do a hot take on something funny that happened in court to one of our lawyers. Maybe opposing counsel did something that they shouldn't. And then we will talk about NDAs, non-disclosure agreements. So let's go ahead and get it started on what is causing the courts in Texas to want to move so quickly. Clint Flanagan, one of the firm's supervising lawyers, he had this comment. He was like, "Is anyone noticing?" No, you asked. You said, "Is anyone noticing? Like, what are you noticing? What's going on?" So.
Yeah, I think something must have been handed down from the Supreme Court. I've heard rumblings, but some counties are notorious for denying continuances, but I think it's become not even a trend. It's happened suddenly that judges are sort of referencing that they're being looked at or graded or something, and that they need to get cases off their docket. So I think something came down. I could have researched it. I apologize for not researching it, but this is something you and I just started talking about with Clint yesterday, and I knew someone would look into it. So I hope you have the actual answer.
I have some answers. I'm not convinced they're the right answers. I mean, Clint made a comment. He said something like he was in some court and the judge had every attorney on his docket come in requiring physical appearances, no Zoom, no virtual. They were all there, and he just went down every case on his docket, and the judge dismissed a ton for want of prosecution. All right, just said, "Hey, you're not moving," just dismissed it. And then the judge, set trials, and he moved stuff forward. I guess I'm a fan of it. I don't know. Do you like things moving that fast? I guess it depends if you're the attorney that's not ready, right? So,
Yeah, I do think regionally there are some differences, and don't no one pick on me like with specifics, because obviously different judges might have different takes. But Clint's over in the Travis County, Williamson County area. Those counties, by and large, Bexar County, they don't set trials. They wait on the attorneys to come to an agreement and set a trial. Once that's done, things get moving and things happen. But they're not going to force you to trial. But what they will do is they will DWOP your cases. And so a lot of times in those middle of Texas counties, what I've seen is if you say, hey, the other side's not moving on this case, will you put it on the DWAP docket? Courts are happy to put it on the DWAP docket to kind of clear their stuff out. Dallas puts your case on the DWAP docket as soon as you file it. They say, you better get you better get them served. They better answer, or you better move for default within the first month, or you're done. Get off our docket. And if you do that, then we're going to set you for trial. And similar to what you were just talking about, I've been on dockets where, you got 12 cases, all agreed continuances, and the judge says, denied, 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 denied. Even though both parties agree, they have great explanations. Judge, we've been trying to depose these people. We've been working on our schedules. We've done written discovery. We're going to go mediate this case. Not just the attorneys who aren't moving forward, but actually trying really hard, and the judges still deny their continuances. And not to keep rambling, but over here in Harris County, where we are, the traditional approach is you file your case, a DCO is issued. You're probably not going to be reached on your first or second one, but if you are, you better be ready to go. But, not to use the old edict of first one's always free, but a lot of times your first continuance is going to be granted. But I don't even know that that's true anymore. I think something's going on with these cases. The judges are trying to get them moved forward, but I've got 2018 cases that I still can't get heard either. So there's
the old running joke is that if attorneys are good for nothing, they're good for continuances, right? Motion to continue everything. I like to see these cases move a little bit faster. I'm implementing things at the firm where we're trying to get all these cases ready to try as soon as possible. I love what's going on. I think it's hilarious that you always find a way to attack Dallas. And it's so funny to like how much money would we have to pay you to move to Dallas? If we were just threw money at you and you had to tell your wife, you're like, hey, I just can't refuse this. We're being transferred to Dallas, and you would have to practice up there. I would get great amusement at that. So
I couldn't do it. I don't think there's a number, Phil.
You would run directly to Academy and buy a Mavs.
No, you couldn't. No, Mavs, Rangers.
We'd get the Rangers gear for you. It'd be a little going away present.
Oh, that would be horrible. Don't.
All right. Well, look, we don't have an official answer. I did not see any like Supreme Court rule or anything like that. Now, there could be something internal these judges are doing that we just don't know about. The legal scholars that they just believe that the rules themselves, they think the big driver is this rule 19, this summary judgment overhaul, this 166A. And their theory is, well, we put so much pressure on the courts, and we told you that Supreme Court, if you did this, you're going to put too much pressure on the courts. And now the courts have these mandatory deadlines, and that's causing them to kind of get rid of everything else quickly. That's one theory, right? You buy it, don't buy it, like it?
Maybe, but the summary judgment thing needed to happen, quite honestly. I kid you not. I had a judge sit on a summary judgment for 9 months. They've got to set the hearing, and they've got to give us a decision. If the answer is no, the answer is no. Just deny the summary judgment. And a lot of times it is very hard to get these hearings. You file your motion timely. You're 6 months out from trial, and they say, oh, we can give you a court date in January. He said, what are you talking about? What is so... And look, I don't understand the inner workings of courts. I don't want to disparage any court, any judge, but if we're timely filing motions for summary judgment, they've got to be heard before trial. You've got to give us time to get them on the docket, have them heard before trial, because the whole point is to try to avoid trial.
I mean, I don't think we're the only jurisdiction that requires the judges to hear summary judgment motions at a certain day, certain time. So maybe that's not it. Some other theories, expedited actions have been expanded right up to $250,000. So maybe that's putting some pressure on the court. And here's an oldie but a goodie. You remember when we changed the disclosure rule where you used to have to request initial disclosures, and now they're just mandatory. And that's one more thing. So the legal scholars are saying all of these things together are causing courts to have to move faster, and they're having to get rid of some of the cases that are just taking too long to try to make room. I guess that's the theory. So
Maybe it still seems a little weird to me. Again, I don't know the inner workings. If someone wants to tell me why I'm stupid and ignorant, that's fine. But it's kind of like if the case is sitting on the docket and not doing anything, who does that
yeah.
really hurt? Who does that bother? Does it tax the staff? Is the staff required to, you know, pay attention to it and say, oh, what are we doing with this 2017 case? Or can it just sit there until the litigants are ready to move forward? And if someone's not ready for trial, but someone else is, why can't they
Yeah.
go?
Well,
Um, maybe
I
I'll
don't.
never.
I'm going to do some more research on it. I'm going to circle back to see if there's any better answers out there, and we'll just see where that goes. And we also need to interview some other lawyers and see if they're seeing the same thing. So, all right, let's move on to our. This isn't really a question. It's kind of interesting. I saw this in the lawyer chat space. I had a fun day in court. Quote. I had a fun day in court. Watched someone go to jail for not paying child support. Then my opposing counsel threw an exhibit at my co-defendant counsel. Right. So you know, if you're in a district court, I mean, I guess it depends on the county. I mean, you could just be in a district court somewhere, I guess, and it could be a family law court. And I guess the judge did
Usually
county
county
court.
court. It's usually county court. You could, and I honestly miss these days because this is how you
Mhm.
learn stuff. You know, you get there at 9 o'clock. You're on a probate docket, but there's a suspended license docket in front of you. There's a divorce docket in front of you. There's, child custody hearings, all that stuff. And so you're just kind of sitting there. It's a small county court, but you're seeing all this other stuff in front of you.
Well, and that is fun actually to see some of that other stuff. I don't in some of these larger counties, they typically have specialized courts that see all the family law matters. I'm sure in the smaller counties they don't have that. So,
Yeah.
but have you ever
Yeah, here in Harris County, all the family courts are different district courts that we'll never see
Mhm.
unless we're parties to them, not lawyers in
We
them.
don't wanna be parties to that. Have you ever had something crazy like that? Have you ever had some opposing counsel do something just crazy? That's the one of the craziest things I've ever heard. I can't imagine being in front of a judge and, like, having something thrown at me, right? I mean, I'm sure the judge wouldn't you if you were the judge, what would you do? I'd be like,
Oh, it depends on the judge, but I've I've had judges yell at me for far less. I one time I recall recently I was holding up an exhibit. And I wasn't trying to be particularly aggressive, but it was like a contract, and I was holding it up, and I said, "But this is what this says." And I was examining the witness, and I held it for a while, and the judge didn't like it. The judge said, "Counsel, you can put the exhibit down now." And honestly, I was just holding it in my hand, kind of going on with my examination. I wasn't trying to be disrespectful to the
yeah.
witness, but no, judges do not like disrespect. Of all the things they don't like, disrespect towards a witness or the court or the court staff or another attorney,
Yeah.
they don't like.
But you didn't throw the exhibit at anybody, so this
Certainly
was
not.
over the top. I don't know what the judge did. We need to ask the attorney what the judge did. I could see, type of contempt kind of thing going on there, but you
They
who
could.
knows? So, well, we're gonna have to follow up on that one. I could see contempt. I could see I could see maybe a bar complaint. Even I could see the judge filing a bar complaint in that regard. I'm not sure. I don't have the rule on top of my head of what the bar rule. There's no specific rule about throwing things in a courtroom, but got to be cordial. So
I think the lawyer's creed. I've had judges ask me about the lawyer's creed, even though it's not binding, but some judges hold the lawyer's creed in high
we think
esteem.
the creed probably does say something about throwing exhibits or throwing things at opposing counsel. Don't do it.
I think it just says be respectful or treat other attorneys with respect.
Yeah.
I don't know what it says.
Here's let's move on to our next topic, our final topic, non-disclosure agreements. Have you done any NDAs or I mean, you've seen them. I don't know if you ever drafted any, but
Sure. We do them a lot in the business context, but we've done some in the personal space as well.
Those are kind of the more fun ones.
We had an attorney. We had an attorney meet someone in a bar to sign an NDA, thinking that it was going to be a group meeting, but really the client had just sent us to meet with his ex-girlfriend. So that was interesting.
All kinds of, you can have some personal NDAs that are probably much more salacious and interesting than our typical business NDAs, right?
It
Yeah.
was.
Typically you see them
It
in a
was.
business context. Usually you have a potential buyer sign a non-disclosure agreement. If you're the seller, you're going to let them look at your books and things like that. A lot of NDAs are being written by AI now, as opposed to them coming to lawyers. So watch out for that. I've got some kind of best practices here. If you're talking about non-disclosure agreement, there's sort of a myth out there that any NDA is better than no NDA. In Texas, a lot of overly broad or poorly drafted NDAs, can be completely unenforceable, and courts do scrutinize these things. One of the big pitfalls is hidden non-competes. You try to sneak like a non-compete in an NDA, and that doesn't work. Non-competes are their own thing, and they kind of need to be, treated as their own thing, right? So, there was a time period there, Chris, where you were reviewing a lot of non-competes early in the firm. So I think you remember doing that a lot. But yeah,
Yeah, we've got several litigation pieces
yeah.
on those.
You have to have the right consideration, for NDAs. Okay, it's not like someone can just sign an NDA and there could be no consideration. You typically have to have some trading of promises. It doesn't necessarily have to be money, but there's some cases out there about why non-disclosure agreements are unenforceable for lack of consideration. Mutual exchange of value, it's like
we call that hush money.
Well, yeah, and that's right. Exactly. You want to talk about those more interesting non-competes, right?
I understand. I'm sorry. We'll keep it
Well,
related to business.
I mean, those are more interesting, but also indefinite restrictions, you'd be careful about indefinite restrictions out there. That's kind of a how long do you have to keep it confidential and that kind of thing. And then, some other tips on NDAs, if you're going to have a good NDA, be sure it's got an attorney's fees provision in it. That's always a good idea. And be sure you've got a clause that explicitly grants injunctive relief, right? So that way, they consent to irreparable harm, and kind of makes your TRO a little bit stronger, where the parties agree that if you were to do something, it would constitute irreparable harm. That's kind of kind of some tips there for you.
Although that's kind of like signing a document saying, I affirm that I have capacity.
Yeah, right.
I affirm that I'm not having a gun held to my head. Well, affirming that it's irreparable, is it really? But so that leads me to a question though. Are you telling me, again, in the business context, it makes perfect sense. And I'm not trying to make this a gossip show. I'm really not. So looking at someone's books because you want to know if you should buy the business, that's a perfectly legitimate reason for, hey, we're going to show you this, but you can't use it against us. You can't publish it. That information is going to be stale after a couple years. If really an NDA for, okay, people had a relationship and you want to keep that quiet, that could damage you 20 years from now. Okay. That information doesn't go stale. Are you telling me that may not be enforceable in 20 years?
I don't think so. I think it goes to a damages thing, right? Like in your example, there is damages 20 years later. It's kind of risky if you're talking about, okay, you looked at some books or something like that, and you happen to disclose some profit numbers 20 years later. Probably not much in the way of damages for that, because those profit numbers are going to be wildly different from, 20 years later. So I think that kind of tip goes to damages, but I don't think there's necessarily a limit to sort of survival clauses in contracts. And that's really what that is. You see a lot of survival clauses like, this clause survives the termination of the contract and all that. And we typically don't put a definite, term on that survival, but it's a good idea to certainly be thinking about those things in the context of an NDA. How long could the damages go out? What are the risks here if they get out 5 years from now? And maybe it's something you want to put expressly in the NDA. So, yeah.
Okay, that
All
makes
right.
sense.
I think that brings to our show to a close. I've been your host, Phil Silverman. Chris Hild has been my co-host today. Like us, follow us, review us wherever you get your podcast. And as a reminder, nothing in this show is to be considered legal advice. And this has all been entertainment for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your week and weekend.